The most comprehensive and legally grounded submission. On legal certainty, the best interests of the child, and the misapplication of the LVU in practice. I submit this letter to draw attention to a serious and increasingly systemic problem in the application of the Swedish Act with special provisions on the care of young persons. This matter concerns legal certainty, children's long-term protection, and the fundamental rule of law principle that families must not be separated without compelling, objective, proportionate, and evidence-based justification. The LVU constitutes one of the most intrusive forms of state intervention into private and family life. Through coercive measures, the state assumes custody of a child from their parents. For this very reason, its application must be governed by exceptional restraint, high evidentiary thresholds, strict proportionality, and robust legal safeguards. Where these requirements are not met, the law risks producing precisely the harm it was intended to prevent: serious and lasting harm to children. LVU must remain an absolute measure of last resort. By its purpose and legislative intent, LVU is designed exclusively for situations in which a child is exposed to concrete, serious, and demonstrable danger. It must not be applied on the basis of assumptions, intuition, subjective concern, or discretionary interpretations by individual officials. LVU must never be grounded in unverified or contradictory reports of concern, rumors or second-hand information, assessments lacking objective and verifiable evidence, deviations from social norms or lifestyle choices. The use of coercive care without evidence is incompatible with the rule of law and with international human rights standards. The rule of law must apply equally in child protection proceedings. It is neither reasonable nor legally acceptable for parents to face the loss of their children where they have not been reported to law enforcement, have not been convicted of any offense, are not subject to substantiated allegations, pose no documented or demonstrable danger. In all other areas of law, individuals accused of serious misconduct are guaranteed due process, evidentiary scrutiny, proportionality, and independent review. These guarantees must apply equally, if not more stringently, when the state intervenes in family life and permanently alters a child's development. The Convention on the Rights of the Child, clear in law, deficient in practice. Article 9 Protection from arbitrary separation. Children may be separated from their parents only when such separation is absolutely necessary for the child's safety. This requires compelling, objective, and well-documented reasons. The child's right to family life constitutes a core human right. Article 3 The best interests of the child. The best interests of the child cannot be reduced to subjective or emotional assessments. They require facts, evidence, proportionality, and a thorough evaluation of long-term consequences, rather than short-term or administratively convenient solutions. Article 12 The right of the child to be heard. The child's views must be genuinely heard and given due weight, not filtered, reinterpreted, or disregarded when they conflict with a predetermined outcome. Domestic law must be interpreted consistently with international obligations. The Social Services Act. The primary obligation of social services is to support and assist families, not to resort to coercive interventions unless absolutely necessary. LVU, Sections 1 to 2. LVU is intended solely for circumstances involving a manifest risk of serious harm, not generalized concern, social difficulties, or resource shortages. The principle of proportionality. In accordance with international and European human rights law, the least intrusive measure must always be chosen. Where support is sufficient, support must be provided. Coercion must remain a last resort. Out-of-home placements carry well-documented risks. Extensive research demonstrates that children placed in out-of-home care face elevated risks of mental health disorders, poorer educational outcomes, repeated separations and attachment disruptions, long-term psychological trauma, and, in some cases, exposure to further abuse. Accordingly, such placements must be exceptional and limited to situations involving proven, acute, and immediate danger. Children must be supported, not punished through family separation. Children must never be removed from their families due to their own behavior, mental health difficulties, school-related problems, running away or norm-breaking conduct. It is the responsibility of the state to provide treatment, support, and adequate resources, not to punish children by severing family bonds. Kinship care must be the primary alternative. Where removal is unavoidable, kinship placement must be the default option, prioritizing relatives, close family members, individuals with whom the child already has a secure attachment. Placements must never be influenced by financial or institutional incentives. Particular concern: families of children with neurodevelopmental and complex needs, parents of children with severe autism, elopement behavior, impaired executive functioning or consequence awareness, extensive functional impairments, must be guaranteed access to personal assistance, respite care, and specialized support. The absence of adequate public support must never be transformed into grounds for coercive care. What constitutes legitimate grounds for intervention, and what does not? Legitimate grounds include proven physical abuse or severe psychological abuse, serious neglect resulting in documented harm, severe substance abuse preventing basic caregiving, acute and immediate danger to the child. Grounds that must not justify coercive care: concern without evidence, multiple unsubstantiated reports, adolescent conflict, parental neurodivergence or mental illness per se, poverty or social vulnerability, parents exercising their right to question authorities. Manifest risk requires demonstrable and immediate danger. Manifest risk does not mean theoretical or speculative harm, intuition or professional concern, assumptions that things might deteriorate. It requires documented evidence, concrete and serious danger, immediacy such that the child cannot safely await supportive measures. The threshold is intentionally high, and must remain so. BBIC and the best interests of the child, when protective concepts are misused. BBIC is an assessment framework, not a decision-making instrument. When used to justify coercive measures without evidence, it loses its protective purpose and becomes harmful. The best interests of the child are not synonymous with the subjective views of social authorities. Administrative efficiency. Placement is a default solution. They require protection of attachment and continuity, support before coercion, long-term impact assessments, respect for family life, formal demands to legislators and oversight bodies. I formally call for the following safeguards. 1. Substantially higher evidentiary thresholds in LVU proceedings. 2. Independent and external review of decisions. 3. A prohibition on LVU based solely on concern or rumor. 4. Full and effective implementation of the Convention on the Rights of the Child. 5. Mandatory prioritization of support measures. 6. Kinship care is the norm. 7. Protection against financial or institutional incentives. 8. Accountability of public officials and independent oversight. 9. Guaranteed assistance and support for families with children with complex needs. Serious errors must not occur without consequences. Conclusion. This is a matter of legal certainty. This is a matter of children's lives. This is a matter of ensuring that coercive care is never normalized. The misapplication of LVU damages attachment, fragments families, and leaves irreversible harm. Such interventions must never be justified by minor issues or administrative convenience. Children must be protected from real and demonstrable danger. They must not be protected from their parents.